Safety and License Advisory Board meeting to order. This time we'll go to item B, which is a roll call and a certification for quorum. Mr. Keith Bell, presiding officer, I'm present. Mr. Michael Gramillion. Mr. John Lewis.
Present.
Ms. Stacy Malcolm.
Present.
Mr. Stephen Pomacall.
Present.
Mr. Mark Roach.
Present.
Mr. John Sparrow.
Present.
Mr. Gary Strauss. Mr. Marcus Lundgren.
Present.
As the chairman, I do certify we have a quorum present. The meeting has been posted in the matter as prescribed by law on the 7th day of July 2017. At this time, we have several new members of our advisory board. At this time, I'd just like to allow everybody to make some introductions, your name and what industry you're from, and what area of the state. So, Mr. Pomacall, you want to start that, and we'll just work from left to right.
Randy Pomacall, I'm an electrical contractor here in the city of Austin.
I'm John Sparrow. I'm a developer and home builder here in the city of Austin.
Marcus Lundgren, I'm a representative for the IBEW Local 602 out of Amarillo, Texas.
Keith Bell on Intex Electric in Forney, Texas, master electrician.
Stacy Malcolm, I'm from Houston. I'm a licensed professional engineer in Texas.
John Lewis. I own Lewis Sign in Buda, Texas, just south of Austin. I'm a master sign electrician.
Mark Roach, master electrician. I'm in electrical supply in Corpus Christi, Texas, and is that?
All right. Well, thank y'all. Welcome our new members. Is this your first meeting, Mr. Lewis? Second? First meeting. So, Mr. Lewis, Ms. Malcolm, and Mr. Lundgren, we welcome you to the advisory boards, and hope you find this service insightful as well as fulfilling. Moving on to item C is training for advisory board members. This time the chair would recognize our general counsel, Mr. Doug Jennings. Mr. Jennings.
Thank you. Take this with me. Testing, testing. Seems to work. Thank you very much. I am a new face to many of you. My name is Doug Jennings. I'm Assistant General Counsel for the program. I believe last time you met, there was a different attorney in place. I plan on being here for a really long time, so get used to it. We are going to, oh, my boss is here. So I'd just like to run you through some of the annual training. We'll touch on some of the topics that many of you have seen before, some of you haven't. Just keep you on the straight and narrow. Let you know about open meetings, open records, agenda making, rule making, things of that nature. Try to keep it short and sweet. You've got some more detailed materials in your packets. All right, so yes, as I said, we'll be covering the Open Meetings Act, the Administrative Procedure Act, and the Public Information Act. The Open Meetings Act is what we'll tackle first. As stated in the statute, the primary purpose of the Open Meetings Act is to ensure an open and transparent government. And a meeting under the Act must meet the following requirements. Notice is very, very important. Today, for this meeting, which is a meeting of a government body, our agency was required to post notice of the meeting with the Secretary of State, which had to be posted at least a week before the meeting. The Secretary of State posts that notice on their website, and we're required to post it on our website as well. Now, just a little terminology here. A quorum is a majority of your body. You have 9 members on your board. 5 members will need to be present in order to take any official action. If a quorum is not present, you may meet and continue to hold discussions, but you may not take any official action, such as recommending a rule for adoption or anything of that nature. And also, you may only meet to discuss public business or policy under your supervision or control, and you can only take formal action on the same, which is fairly obvious. You're not going to adopt rules for the practice of massage in this body. That should never come up. Now, it's obvious that today this is a public meeting. We are meeting in a suite of a state agency, but sometimes it gets a little cloudier. let's say that a number of you are at a convention, discussing the electrical industry, and there's maybe a cocktail party thereafter. The question arises: does that constitute a public meeting, since so many of you are there? Well, this gives us a little guidance. If a quorum of your body is present at a social function that is unrelated to the business, the gathering is only subject to the Open Meetings Act if the members engage in a verbal exchange about official business over which they have supervision or control. And you're not engaging in a formal meeting if there's conversation amongst the members that is incidental to the social gathering. So you'll see that perhaps if there's a social gathering after a convention that is very specific to your industry, there may be some issues there. And so you may want to avoid talking about your public roles and your public duties and your public business. However, if you just kind of, the chance encounter an unrelated event, the rules are a little bit different. But anytime there's any questions, you can feel free to come and ask me for some guidance. Additionally, maybe at conferences or workshops, if a quorum of advisory members are present, you're not engaging in a meeting, a technical meeting, as long as conversation about the public business or policy is incidental to the event and no formal action is taken. So those are some guidelines for conventions, conferences, and workshops. Just some key things to remember is you just always need to be aware and to some extent wary if you are meeting, if a quorum of your members is meeting in any setting that is not formally noticed and not part of a meeting noticed and held by this agency. You just need to be aware of that and try not to engage in some substantive discussions about your program unless you're in a formally noticed meeting like we're in today. And the last key point to remember is beware of the walking quorum. We always harp on this because it's becoming kind of a more confusing issue today with technology. Now, a walking quorum occurs when fewer than a quorum start discussing an issue, and slowly and gradually the group gets larger and larger, the discussion gets larger and larger. So we will take in our example that we have a 5-member advisory board. So a quorum for that board would be 3 people. And we have 2 members who are exchanging emails or thoughts or phone calls back and forth about a particular issue. That's fine. That is perfectly fine. There's no need to put that. That's not a public meeting. But let's say that one of those 2 members reaches out to the 3rd member. And now we have an email chain involving 3 people about official agency, about official board duties and official issues. Now we have what's called a walking quorum, and really that is a public meeting. Because 2 people is not a majority of your body, perfectly fine for you to carry on. But once you get that 3rd person involved, it really raises these issues. And it gets sticky because it can occur during conference calls, video conferences, hallway discussions even. And thanks to the advent of email, text messages, and Facebook and Twitter, these opportunities to create this open meetings issue have really increased. I mean, you could even have a couple of members talking about a particular issue, and one takes to Twitter and says, "Mr. Smith and I had a great talk today about this particular issue," and then your 3rd member, jumps into the conversation, and now you've got this public meeting that's happening on Twitter, and really, there are statutory requirements that have to be met. There needs to be an agenda, there needs to be notice, so you can see how that can easily arise in this context. And so just some good general practices on how to avoid this. You shouldn't meet in small groups and discuss board business and then communicate to other members. And so a good example of this is if you put together a work group. We always put work groups together that are smaller than a quorum, and we do that for open meetings purposes. So for your board, we would say a work group might be 3 or 4 people because your quorum is 5. And that is why we ask when you are in a work group, you keep your findings to yourself until the next meeting. And the reason for that is we avoid the walking quorum issue. If you communicate to a single member, it can actually raise some Open Meetings Act issues. So don't send emails or text messages to a quorum of members regarding official business, even if you're sending those emails individually rather than to the group. And one thing that's really important is don't, if you're the chair or maybe heading up a work group, don't send an email or text or any kind of communication out to your members asking for their opinion on how they would vote on a particular issue, because this is called polling, and it is frowned upon, to say the least. Now, some guidelines for your sessions here today, your general meetings. You will be limited to discussing the specific items on the agenda. And part of this is that, the reason we post the notice online well in advance is so the public knows what you're going to cover. There are no surprises. And can choose to attend the meeting or make public comments when those issues arise. And during the public comment period of this meeting, the members of the public are given an opportunity to speak, and you may set limits on that. We see limits of 3 to 4 minutes typically. One of the things that's really important is that when a public comment is made, as board members, your job really is to absorb that information and not necessarily respond to it. Because if a public comment raises an issue that's not on today's agenda, we just can't talk about it because it hasn't been noticed. The public isn't aware that that topic is going to come up. So we could, if it's a great topic for discussion, we'll put it on the agenda for the next meeting, and then we'll have no problems. And again, guidelines for open sessions to avoid violating the act on the basis of insufficient notice. Advisory board members, anytime you have an idea for an agenda item, communicate it to our staff. You don't raise it on your own in a meeting. We want to have that on the agenda well ahead of time. And whenever there's a discussion, limit it to the particular agenda item. If we get too far afield from what's on the agenda, we're going to have some issues. And just so you know, there are some penalties and remedies for violations of the act. Any interested person, including the media, may petition courts to stop actions taken in violation of the Open Meetings Act. And any act taken in violation of the act is voidable. So if you adopt, if we didn't publish the agenda properly today and we adopted some rules in this meeting, those would be potentially voidable by a court because we didn't comply with the Open Meetings Act. And of course, we have to scare you that there are criminal penalties. Board members who knowingly conspire to circumvent the Open Meetings Law are subject to penalties, including a fine, confinement in county jail, or both. And you'll see in your meeting materials we have some resources on the Open Meetings Act. Jumping ahead, we'll talk about the Administrative Procedure Act, just a quick summary, some nuts and bolts. The Administrative Procedure Act gives some guidelines to state agencies, gives some uniform guidelines for practice and procedure, and also provides for the public's role in participating in the rulemaking process. Most of what we'll talk about regarding the APA in these meetings deals with rulemaking. And a rule is a statement made by a state agency that implements, interprets, or prescribes law or policy, or describes our procedure or practice of a state agency, and doesn't solely relate to internal management or organization of a state agency. And we'll have some good examples. We have a couple of rules we'll be looking at today. And one thing that's interesting for you to know is that any interested person may actually come to this board and ask for you to adopt a rule. And an interested person is anyone who is a Texas resident, who maybe is a business entity located here, or a state governmental subdivision, or a public or private organization that isn't a state agency but is located in Texas. And we'll give you just a brief, this is our little flow chart of the rulemaking process so you understand the flow and also the timing involved for this. So we'll start at a little triangle here. Once the idea for a rule is given to the board or comes to light in our agency, we will draft some rules and send them to you. Once you have approved them in whatever form you've approved, you'll make a recommendation and we will file the rules with the Texas Register. The public will then that'll be published. The public has 30 days to comment on the rules. And when those come in, our office will review the comments and you'll get to see all the comments, but we'll come up with some potential responses. And then you will then look at the comments that the public has made and decide whether or not to make a recommendation to our commission whether or not the rule needs to be adopted. For example, we could propose a rule, get some comments that make us realize maybe it was a bad idea or had some unintended consequences. You can address that and say, we no longer would like to recommend the commission adopt this rule. So that gives you the opportunity to either approve or deny the rule, basically. And then we will take the rule to our commission, our governing body, and they will review the rule filing and comments and figure out whether or not they would like to adopt the rule. If they do adopt the rule, we have to file with the Texas Register again, and the rules finally become effective 20 days after filing. I like to think of the rulemaking process as moving in geologic time rather than normal person time. Everything has a 30 or 20-day 20-day delay, but that's not so much a hindrance to us as it is an opportunity for the public to be involved and make sure that they have enough time to give comment and to respond to any potential rule that we have. We also have a process called rule review. We just went through this with electricians maybe in the last 6 months, a year, so you won't see this for a while. But by statute, we are required to review our program rules every 4 years and determine whether or not the rules are still required. To be honest, we're not going to look at this for a long time, but I'll inform you at the time. I want to make sure we get through this relatively quickly. The last function of the training, last portion of the training is the Public Information Act. You've heard this referred to as the Open Records Act. Here's the full statute. Not going to make you read it. It's in your materials. So we'll give you the short and sweet version. The Open Records Act, or the Public Information Act, makes all documents, records, and other information relating to official business open to the public, with some exceptions. You're a governmental body as an advisory board, so the materials that you generate, by default, there is an assumption that those materials are open to the public. And public information includes any electronic communication created, transmitted, received, or maintained on any device if it's in connection with official business. And that is the very reason you have your iPads in front of you today, and we try not to communicate with you on your personal devices as much, because any information, maybe if you're taking care of business and storing materials related to your role solely on your personal device, that could potentially be something you have to share. And so we like to provide it to you on your government-provided iPad there. The open records process, just so you know, if there is a member of the public who wants to get a copy of any of the materials the agency or your board has put together, they must make a request in writing, and they will send that to the Office of General Counsel. We have 10 days to respond. We're not allowed to ask why a person wants the records. We just ask for clarification. Sometimes the requests are really broad. Please send me a copy of all emails. Well, could you be a little more specific? So we can ask those questions. There are some exemptions. There are some things we don't have to disclose. The dates of birth, email addresses, certain education documents, and documents that we are not allowed by law to provide thanks to the Medical Records Privacy Act and HIPAA. And additionally, we've got some resources in your packet and some good links there. And I think that should cover the three major prongs of the training. I hope that was sufficient, but I'll be happy to answer any questions you might have.
Thank you, Mr. Jennings. Any questions by the advisory board concerning either the Open Meetings Act, Public Information Act, or Administrative Procedures Act presentation? Hearing none, thank you again.
Thank you.
Mr. Jennings. This time, just like to make a few announcements.
Great job, Doug.
Welcome, Brian Francis. I mean, this will be my first advisory board meeting I've had with you being executive director, so I'm certainly proud for you, Brian.
Thank you very much.
And you'll do a great job. Looking forward to working with you.
Appreciate it.
So,
Appreciate
thank you. Secondly, I hope everybody finds our meeting insightful today as we discuss these issues. Lastly, if you want to make public comment, there is a form that you need to fill out, and bring that to Delia and then to me, and if that needs to be. So when we get to that place, I'll ask that. Right now, I've got none. So with that said, we'll move on to item D, approval of minutes, including your packets are October the 6th, 2015. I'm assuming everybody has reviewed those. If there's no clarifications or revisions, at this time, the chair will entertain a motion to approve the minutes.
I will make a motion to approve the minutes for October 6, 2015. John Sparrow.
All right, got a motion by Mr. Sparrow. Is there a second?
Yeah, Randy Palmacall, I'll second.
Second by Mr. Palmacall. Got a motion and a second. Any discussion? Hearing none, call for a vote. All in favor say aye.
Aye.
All opposed? Motion carries. Moving on to item E, public comment. I have no one that has filled out a form to address the advisory board, so we'll move on from E to F. F is staff reports, and item 1 is executive office. At this time, the chair would recognize Mr. Brian Francis, our executive director. Mr. Francis?
Mr. Chairman, board members, I'm Brian Francis, Executive Director with TDLR. And so this is the first time that I faced the board as executive director, and, you know, it's pretty humbling. Bill and I we were a partnership and worked together for years, even prior to coming to TDLR. And the staff has heard me say this a couple times, a couple of the other advisory boards. But I remember, you know, talking to my dad, and I'm like, you know, dude, I'm about to get this promotion to the executive director role. And he said, well, now, Brian Earl, now I know you think you've been running that agency for years. He says, but son, you've only been making suggestions. Bill made decisions, and you had to live with it. He says, and that's a different role. And that's what I've experienced in September, is that there's a different weight to having to sleep with the issues and making the final call. One of the responsibilities I have is signing agreed orders. You know, in that first week, you know, with just the stroke of the pen, I was fining people $6,000, $8,000, revoking licenses. So it sits pretty heavy. With that said, though, I'm fortunate because I have a great bunch of folks. I have a great bunch of people that are holding me up and making sure that my mistakes aren't that glaring. They're fantastic, they're talented, and there's quite a bit of change going on. So if you have Bill moving out of his seat and I slide up to the top one, you know, you've got to fill the other roles. I've got a deputy executive director, her name is Carla James, started in December. She's talented, she's smart, she's aggressive, she's witty, and she's full of energy, and she's a great partner in this crime that we're committing called regulation and serving Texans. We also added a role, chief of staff to our agency, Nick Voenison. I'll have Nick say a few words.
Mr. Chairman, members, thank you. It's a great honor to work with you. We've got an awesome staff. I've been here 6 months now, and it's incredible every day to come in and see these folks and see how hard they work and the passion and that they have for what they do. We're here to help you in any way, and it's been a whirlwind 6 months for Carla and I, but it's a good team, and we appreciate all you do. Thank you.
Nick brings a lot to the table. He is over our Office of Strategic Communications, which is everything external that we talk to the folks, whether it's our web, whether it's our government relations, our public information officer. He's also over our customer service division, which handles more than 500,000 phone calls a year, over 80,000 emails a year as well. So it's been quite busy. TDLR has gone through a lot of changes in terms of size and responsibilities. Going into the new job and then jumping right in the middle of a session, it kind of gave me an odd perspective. So what is really my job? Is my job to attend nothing but legislative hearings, or is it to lead, you know, an organization? And at the time it was both, trying to make sure that the wheels didn't fall off, and only 2 did during that time period. So we're doing pretty good on keeping things going forward. When Bill and I got here back in '99, we were sitting with 20 programs, and in November of this year we'll be up to 38 programs. We had about 149,000 licensees, and in November we'll be topping at about 750,000 licensees. We're going to be at 31 advisory boards. So you have Tamla and Delia, you have Mary, and we're going to add another person to that team to make sure that we provide the advisory boards with the touch and the service that we need. This is an important part of TDLR's success, having these conversations and making sure that we add our smarts on how to regulate, and we get the industry's perspective on how it looks out there in the real world. So we're going to continue to do that going forward. Bill and I had about 145 employees back in 1999, and at the end of this journey, in about a year and a half, we'll be up to about 471 employees. So we were very, very, very fortunate coming out of this legislative session. We were given resources, and that was a big challenge that state agencies are facing. We all were asked to do a 4%, present a budget that had a 4% reduction in it, and we fared very well, and I'm excited about that. We'll be laying out our organizational changes this afternoon to the staff, so they'll kind of see where we're going. I'd like to bring you up to speed on the legislative session. I'm going to tell you a few things that happened globally, and then bring it down to what impacted the electricians. We'll have Delia pass out some information for you. This was hands down the busiest legislative session TLR's ever had. And that says a lot, because we've had some doozies, and I know CJ knows we've had some elevated activity before. But in this session here, we attended over 65 committee hearings. We were in 20 different committees reporting to back and forth. Normally, in the past, we would only go to licensing, administrative procedures, and business and commerce on the Senate side. But to have 20 different committees because of the new programs we have really stretched us thin. But one of the things I wanted to emphasize going into this session was to expand the bench strength. And so we were able to do that. We had about 18 employees that were ready to be resource witnesses at the different hearings. In the past, it was probably Bill, myself, maybe Michael Kelly, and George Ferry, and one other person. So we've expanded that, and that was important. I want to make sure that everybody in the agency has that opportunity to shine, but also that they're prepared to take on greater responsibility, whether I leave and go somewhere else or whether another opportunity presents itself. This session, we did over 214 cost estimates. And just to put that in context, every bill that is introduced at the House or the Senate, they will ask the state agency, so what's it going to cost? How many people do you need to do it? What type of technology you need? Do you need programming? Are you going to have travel associated with it? And they get an idea of what the costs associated with that. We did 214 of those. It was about a 60% increase over the number of cost estimates we've done in the previous session. We were tracking over 341 bills this session to make sure that we were staying on top of it. And 341 sounds like a nice little good number, but it's 341 bills, but it's also all the amendments and the iterations and the discussions and the hearings and the gnashing of teeth that goes with it. So it was quite involved. We have our government relations team was comprised of Michael Kelly, Eric Beverly, Colleen Tran, Mary Winston, and Tony Cuvion, and Nick. They were the core of that team. We just found out that Michael Kelly will be leaving us. He left on June 30th, so we'll have a little void to fill there. But Eric and Colleen, those folks, they're ready to step up and knock out of the ballpark. So what made the session so busy? It's part of our nature to take strategic planning seriously. And so, back in those even number years, Randy, when we go around and we do the strategic planning and we say, what can we do better, or, what do we do well? If you were king or queen for a day, what change would you make? Well, last cycle for strategic planning, we came out with, it was referred to about 56 statutory changes that were recommended. And we went to the legislature with that. We shared the ideas with them. And out of the 56, 52 of them passed. To put that in context, there's about 6,631 bills that were introduced this session, and about 1,028 or so passed. It's about an 18% pass rate. We had a 93% pass rate on the strategic initiatives. And that's a big statement. And it's not necessarily a statement about us. I think it's a statement about the process. That we're getting good information, we're getting the input from the industries, we're getting it from our staff. And I think the legislature really looks at that and says, you know what, this wasn't some issue that just came out of the blue. This has been vetted, this has been discussed, and there's some merit to it. So we were really excited about that. A couple of the items that we included in there were deregulations of different programs. So for the vehicle protection product warranters, that's the club in your car or the vehicle, the VIN etching that you have on your vehicle. Those are ways of protecting your car or retrieving it if it's stolen. That's a program that was under TLR's watch. We went to the legislature and said, hey, this probably doesn't need to have a statewide license. Keep the consumer protection provisions in statute, but don't make the person have to come to TLR to get a license. The same thing with temporary common worker employers. Legal service contracts was another one that we looked at. In the area of towing, we looked at the dual license, which was one of our recommendations, which tells you that everything we recommend isn't always the best idea. But in the towing area, we just said, maybe they don't need to have the dual license. Let's let the tow license allow that person to work as a tow operator, but also in a VSF. So it's ways of streamlining. And I just offer that to say that, we didn't go to the legislature saying, give us more. We went to the legislature saying, here's some areas that government can be smarter, leaner, and that was important. And that message was very well received. In the Barbara Cause programs, You had threading, which had been a legal issue that we dealt with in the past, so that one's completely deregulated. And then also shampoo apprentice, so Keith, you can get your hair shampooed, and it may be an unlicensed person, but I think they're gonna be all right. I know they have a shorter time with John and I when they do shampoos, but that's just how the business goes down sometimes. A couple of other things I wanted to point out to you, and I'm talking from this document here. I'm on the back page. The last one I'll point out is the one at the very bottom. That's 4007, House Bill 4007. Coming out of last session, the legislature recommended that TDLR take over 13 programs from the Department of State Health Services. We took on the first 7 of those programs last October, and we'll take on the second 6 of those programs on November of this year. We discovered that their statutes had a lot of junk in it, a lot of business, or things that were not friendly to business, things that were not friendly to technology, things that were impediments to people getting into the business and that sort of thing. And so the bulk of our legislative efforts were to clean up those statutes. So House Bill 4007 will allow us to be a leaner, smarter agency for those new programs coming over. But it spills over to how we operate all of our other programs. What we learn from those programs accrues to the electrician program. What we learn in the electrician program accrues to those folks that are coming into TDLR. That was part of the busyness that we had. In the second document, I think Ms. Malcolm was already turning there. That's, the engineers, they're just all methodical. They're like, get to it, quit, give me all that fluff, young man. I'd like to turn to I'll go with page 6 of this document. Page 6 identifies new programs that have come to TDLR. Since Bill and I have been here, when we came here back in 1999, we had received a new program every legislative session except for 2 sessions ago. And then last session, obviously, they made up for it by giving us 14 programs. This session, we went back to the trend of getting more responsibility. House Bill 100 is transportation network companies. That's the group like Fasten, Rideshare, Lyft, Uber. Those companies are now under our watch. And it's just the company license that we are over. Our statute looks very much like it does in like 42 other different states. So we have responsibility over the company to make sure that they're following the rules and the guidelines. The companies have certain standards they have to put in place in order to vet the drivers, but we're not reaching down to the drivers. That happened immediately. So on May 29th, when the governor signed that bill, it became part of the TDLR family. House Bill 162 is a new program, but it's very narrow. It simply says that TDLR will approve online responsible pet owner programs. Basically, if somebody has been convicted of animal cruelty, the judge can now say, you're going to do a community service and you're going to go view this online course. So it's going to be very similar to one of our programs that we took over with the Department of State Health Services, or will take over in November, and it's offender education program. Same thing, that if you have a driving mishap, if you are driving while intoxicated, that sort of thing, the judge can require that you take education. So this one's going to be very similar to that approach. House Bill 3078, that's the podiatrist. It's medical podiatrist. They will start on September 1. That was a standalone agency. They do a fantastic job. Just that they only had 4 employees for the whole agency. And in state government, whether you are TxDOT with 20,000 employees or TDCJ with 30,000 employees, or the podiatry board with 4 employees, you got to do the same type of reports. I mean, you have to do all the reports to the state auditor's office, to the comptroller's office. And so imagine having to answer the phones, issue the licenses, do complaints, have the board meetings, do all the reporting, and you just got 4 people doing it, the education requirements. And so the legislature said it may be better under TDLR, not because they weren't doing a good job, but because we have a broader resources for the industry and for those individuals. And then Senate Bill 589 is behavior analyst. That program will start in June of next year. And that program, basically the individuals who are licensed underneath that program provide service to young folks with autism, and those hearings, they, so if you've ever gone to a legislative hearing, the room is packed, and maybe 10% of the room are normal human beings, and then the other 10% of the room are the other human beings that are lobbyists that are there, and they're focused, and they got like 16 bills they're working on, and sometimes the normal human beings kind of get in their way. You're like, get off that table, I got work to do. And then these particular hearings, they were bringing 5-year-old, 6-year-old kids to testify, and the room was silent because the kids couldn't speak just 3 years before. But they had this training, this assistance from these folks, and to see the miracle that happened. And it even made some of the lobbyists pause for a little bit, like, that's sweet. Okay, get off the table, kid, we got work to do. So, but I was touched by, to see how powerful this program is. So that'll be coming on board on June of next year. And what does it have to do with electricians? Well, I think it has everything in the world to do with electricians, because those are the programs that will be competing for your time with us. We want to assure you that you're still going to have the full breadth of our resources at your disposal at these meetings and during the day. We still answer the calls. You guys are, I think, the number 2 or number 3 highest volume of phone calls that we receive for the program, and we're answering those in 3 to 3.5 minutes. So we're still taking care of you guys where you need to be taken care of. I'd like to touch on 2 bills that directly impacted the electrician program. Mr. Chairman, I know there's an agenda item later on that deals with the bills and bill implementation. I've got to leave after this presentation, and I apologize for that. If it's okay, I'll just kind of compress this presentation into that one. I'll start with House Bill 1698. There should be a copy in front of you that Delia just passed out. 1698 will create a license for journeyman industrial electricians. These folks can already do the work out there in an industrial plant. They can do it under the apprentice license. They can do it under a journeyman license. That doesn't change. They're not required to have this license to work in that area, but this license came out of some discussion saying that it may be a good idea to create a path for these individuals that are specializing in that industrial work out there. I was talking to Jerry, and he was correcting me. Yesterday I misspoke when I was laying it out. The examination for these individuals still going to come out of the National Electrical Code. It's just going to focus on those chapters that deal with this type of work. Instead of having the broad electrical code and the residential and the commercial side of it, it's going to focus on the chapters that relate to it. So there's going to be a lot of work that the staff is going to have to do. There's going to be a lot of work that the board's going to have to be engaged in as we start working with the subject matter experts to develop the examinations, getting the programming up. We're going to have to build that into our system, the continuing education hours, just the applications from a licensing standpoint. And so we'll start working on that program today. We rolled out our bill implementation team yesterday, and so folks are going to start putting that heavy lifting that comes with that program. Mr. Chairman, I will highlight real quickly the timelines just to give you guys a ballpark of what we're shooting for. Particularly with this program here on the industrial electricians or journeyman electricians, we anticipate that we'll need to have an advisory board meeting in the week of February 14th of 2018. So at that meeting, you'll have rules that are dealing specifically with this program, kind of mimicking if you see the sign electrician language in the rules or the master electrician language in the rules. You'll start seeing that body of information in there. At that meeting, we will ask the board to recommend that those rules be published. They'll do their 30-day comment period like we do with all rules. We'll bring you back in April for another meeting to go over the rules as published and all the comments that were received, and ask the advisory board at that time to make a recommendation for the commission to adopt those rules. And we'll shoot for the rules being adopted by the commission at a May 21, 2018 meeting, and then be ready to start taking applications probably in July, which is ahead of the curve on this program. So you'll be getting updates from the staff on where we are on exam development, where we are in the programming as we move forward through this process. We did this for the 17 or 18 or 20 bills or 30 bills. So we have bill implementation plans for all of our bills that came out of the session. So we had to try to tie and make some sense out of, how these things flow through the agency. Jerry and Ray are going to be instrumental on this. I believe David Gonzalez is the team lead for that activity. So we've got some of our best people working on it. House Bill 3329 does not impact TDLR directly, but because it amends our statute, it's appropriate for us to discuss it. What it simply says, and my friends in municipalities will say, well, it's not simple, Brian, but it's pretty straightforward what it does. It says that a municipality cannot collect a permit fee, registration, administrative fee, or any other fee from an electrician who holds a license issued under this chapter for work performed in the municipality or region. The subsection does not prohibit the municipality or region from collecting a building permit fee. So if you were working in a city that said, hey, we need to know that you're working here, and there was a registration of the master electrician, the master sign electrician, the journeyman electrician, whatever, and if there was a fee, $1, $200, $300, $600 fee, this prohibits that municipality from assessing that fee for that electrician to be registered there. That's a game changer for some of the cities. And that's something that I know that we'll still have discussion in. You'll probably be following the summer to see how they're going to handle that. But I would keep, I'd keep an eye on the different municipalities that you're working in, just to see what that impact's going to be. I would imagine that if we were faced with that challenge, we would be trying to find and identify different ways to recoup that revenue or to lower our costs associated with the activities that revenue is funding. So that's something that doesn't impact us directly, but it does impact our friends that are the building officials in those municipalities. Mr. Chairman, that is all the information I have, but I'm available to answer any questions that the board may have.
Thank you, Mr. Francis. Any questions by the board concerning the executive office staff report or these legislative session updates? Yes, sir, Mr.
I've got a question. Mark Roach. Brian, congratulations, man. I'm really
Thank you
excited.
very much. Appreciate it, Mr. Rowe.
You were one of the driving forces for my decision to continue on in the on the board. Really looking forward to working with you. I think a lot of you. The bill regarding municipal fees, is it industry specific? Since you have an electrician's license, they cannot charge you a fee as an electrician, but I know that some municipalities want to register anybody conducting business for any reason. And so does this override that? Does this forego that?
It is targeted just to electricians.
Just to
And specifically,
electricians.
when you look at House Bill 3329, it says an electrician licensed under the statute. That obviously envisions folks that are doing electrical work that is exempt. There's quite a few exemptions for electrical work, but it says an electrician licensed under this chapter. So it is laser there. Our air conditioning contractors that have to register with the city, they still have to pay their fees. Water well driller and pump installers still have to pay their fees, but it's specific to electricians.
Okay.
Any other questions concerning executive office? All right. Thank you, Mr.
Mr.
Francis.
Chairman, again, I apologize, I
Yes,
have to
sir.
leave. Got a few things taking place this afternoon.
Yes, sir. Moving on to item F2 is the compliance division. At this time, the chair recognizes Mr. Jerry Daniels. Mr. Daniels.
Morning, strangers. Long time no see.
It's been a while.
My name's Jerry Daniel. I'm the chief electrical inspector. Is this thing working? I'll talk loud. If you'll take a look at your staff report under the compliance report, you'll see all the activities and projects we have. This is just a short list highlighting the main ones. The truth is, we're very, very busy, going every way. People call me about a meeting date or something that we can do, and I literally have to get it on the calendar a couple of months ahead to get them on there. Would like to point out a few things on there. If you actually see the Eaton Experience Center, that is a center that's been built down in Houston. It's actually a state-of-the-art training facility. If anybody ever has a chance to go by there and see that, I would recommend you do if you would like to. We have direct access to get you in there. It is phenomenal on the training. In fact, Mr. Reichel, if you look at the end of the activities, Mr. Reichel actually took a training trip down there for our enforcement department. It helps them to understand the equipment, that when we have a complaint, what the complainant's talking about. They actually get hands-on to see every bit of this that's being done. In fact, Mr. Reichel indicated that they had asked that in the future, we help them with some mock displays on the residential and stuff for hands-on training on that. Very wonderful facility, and I would highly recommend if you get the opportunity to take a look at it. You'd be more than impressed. Also, you'll notice I can't get into some of the inspections because of what's going on legal-wise, but I would like to point out the LED. LED's becoming a big deal. The code requires that LED retrofit to be a listed and labeled kit. It doesn't mean that we can just go buy some lamps that are LED out of Shanghai, China for $5 and stick them in a fixture. They've got to be listed and labeled per the National Electric Code 110.3B. Not only do they have to be listed and labeled by the one of the 17 nationally recognized laboratories by OSHA, but we have to install them correctly. Even when we get listed and labeled stuff, if we don't install them correctly, we can have serious problems. We just looked at a building where they put them on the emergency system. When we cut the power and turned the emergency on, it looked like something out of a horror show. Everything was like strobe lights in the building that were emergency. And we found out it was because the listing and labeling, they were not allowed to be on an emergency system. They had actually purchased the wrong light for that. So that's a big deal. As we scroll down to the concerns of the electrical industry, that's one of them in there. And unless the city specifically amends the state electrical code on 110.3B, then anything being installed in the state has to be listed and labeled and installed by the manufacturer's listing and labeling to make sure that we make compliance. You'll see some of the other things. You would think 13 years into this program, people would be marking their vehicles. We're still finding it all the time that they're not marked. We're still finding that we actually have proposals and contracts and invoices that does not have the TDLR information, their TECL number. These are some issues that we need to address and that all contractors need to look at them. It's what we call the low-hanging fruit. You get in trouble and then all of a sudden all this other stuff comes up, and it's real simple to fix by putting this on your stuff. I tell the contractors, if you don't have a format to put it on, go buy you a rubber stamp with this information. Stamp every one of your invoices, contracts, proposals. So we're trying to keep them out of trouble. Lastly, we've coordinated with NFPA to do our 3-year cycle of training with the 2017 NEC that's coming up September 1st. We're having training for the AHJs that do electrical inspections. We want to get the electrical inspectors up to what they need to be doing. I know you as a contractor, you hate to go out there, one inspector tells you do this, you come back and another one tags you for something else and it doesn't even meet the code or anything. That's called the hip pocket rule. We want our inspectors to be following what the law, the rule, and the code actually says. So this training is being provided free 1 day, and it is from NFPA, our liaison, Jeff Sargent, and also NFPA has been kind enough to give everybody that participates a brand new softbound code book that will be there. Now, it is only for electrical inspectors at AHJs, and that is NFPA's rule, but I did talk to Mr. Sargent, and he told me anybody on the advisory board that might wish to attend one of these trainings that we're having on the 18th in Irving or the 20th here in Austin, that you could get with me and I will get you in. Also, Ms. Malcolm, I'm working with NA down in the city of Houston. We're gonna have training on the 20th and 21st of September in Houston. We're working on a location, so if you would like to attend, that would be great. I know you come very highly recommended from Mr. Strongberg. He worked very closely with us. In fact, he was on our exam board. So here's my recruiting pitch. We'd really like to see you on our Zen board and help us out to make sure we're getting it all right. But it's very good to have you aboard. You do come highly recommended. So if anybody would like to attend this training, if you'd get with me afterwards, I'll make sure that you can get into it. And again, it's going to be real good having Mr. Sargent down here from Boston all week long giving us the training. If you have any other questions, feel free to ask me. I'm more than happy to answer.
Thank you, Mr. Daniels. Any questions by the advisory board concerning the compliance division report? Thank you, Jerry.
Thank you very much, John.
Moving on to item F3 is the Enforcement Division. At this time, the chair recognizes Mr. John Medlock. Medlock.
Good morning. My name is John Medlock. I am a prosecutor with the Enforcement Division. Can I go through some of the case highlights, some of the recent sting activities, and some of the statistics that we have for the last couple of fiscal years? The first one is a case that it was a default order against a Mr. Josh Holloway with a penalty of $38,000. Mr. Holloway is a repeat offender. He was cited in this particular instance for performing electrical work without a license twice in 2016, and then on 9 separate occasions was found to have been offering to perform electrical work either through various Craigslist, Facebook, ads, those types of mediums. We sent the NOAV to him. He just never responded, so a default order was entered against him for that $38,000. With some of these bigger fines, what we do is after we can't collect them, we send them over to refer them over to the AG's office, and Mr. Holloway's penalty has been referred over there at this current time. The second one was an agreed order against K-Bar Texas Electric, resulting in a $7,000 administrative penalty and a 1-year probated suspension. In that case, and we also required them to get a new master because the previous master had a 12-month suspension from another enforcement case. In this case, essentially they had entered into a contract with Sundown Electric to replace some light poles. The respondent's contractor's license at that time was expired. And furthermore, some of the employees failed to follow the code when installing these light poles, and unfortunately one of the employees was electrocuted and passed away. They have paid the penalty in this case, but their probated suspension will be up on September 26th of 2017, so they still have a few more months to keep clean. Mr. Gerald French was another default order with, as you can see, a pretty high administrative penalty of $41,000. He is kind of he has dual license. He has an ACR contractor's license and the electrical license. So in this particular case, only $5,000 of the $41,000 penalty was resulting from electrical. But we did revoke both licenses because pertaining to the master electrician, we found out that his experience verification was fraudulently submitted. He had used fictitious work to enhance his qualifications to get that master's license. So as a result of this case, we revoked both of those licenses. He did not respond to this NOAV either, so that's why it was a default order, but it did not stop us from revoking the license. On January 27th, we had a commission order, a case against Mr. Michael Dean. He initially had posted some advertising for electrical work. In addition to that, one of our department investigators contacted him under the guise of STEAM, see if he would offer to perform work. He did. We took that case to a hearing, and the SOA judge submitted a proposal for decision, or a PFD, finding in our favor, and the commission ultimately found a $500 penalty was appropriate to go against Mr. Dean. The last case I want to talk about is an agreed order against an Edward Vallet, also doing business as Vallet Electric Company, resulting in a $1,500 administrative penalty. He failed to perform electrical work to the code by installing a surge protector using the wrong size breaker and the wrong size wiring. And he also failed to properly label that panel, and he didn't install the breaker correctly. We issued him a $1,500 penalty, and he has also paid that. Regarding some of the sting work since our last meeting, we've done looks like a few different stings here. The first one was in September of 2015, and it was down in the McAllen area. It was, at the time, it was the largest sting operation we'd ever occurred, and it resulted in 53 cases of unlicensed activity being open for the department. We've processed all of those because it has been 2 years, and so we've moved on. And in February of 2016, we had another sting. This one was in the Pearland area. It was also worked with a local news station in the area to help broadcast awareness to the general public, to make sure that when you're looking for an electrical contractor, make sure that they have the proper licenses, make sure they have the required insurance, and that you're not just going on Craigslist and finding somebody that says, I do electrical work, because it is very important, because there are a lot of safety implications. Also in November, later that year, we did another sting out in the Houston area again, and they had 43 cases, and again, we partnered with the local news stations. And we find that to be effective as a way to not only help deter people, but it also broadcasts out to the public to get that information out there, to say, hey, be on the lookout, this is your home, make sure you're protecting your assets, and make sure you're getting the proper licensed people to take care of this work. Since the last advisory board, we have had 721 cases closed with some form of disciplinary action, either through an administrative penalty or revocation, a probated suspension of some sort. Of those, half of those were for individuals that were engaging in unlicensed activity. Still a big problem. We're still going to find it out there, and we're still going to keep going after it. If looking at the statistics, so we've got a full year of fiscal statistics to look at under fiscal year 16. As you can see, we opened up 2,400 cases in fiscal year 16, so that was from September 1 of 15 all the way to August 31st of 16. That's our fiscal year. And you can see we resolved slightly more cases than what we had, but that's because we have a number of cases coming in each year, so we obviously do have some sort of backlog. We assessed almost $1 million worth of penalties in 16 and recovered about almost 200,000. Rationale for that is because a lot of them are either unlicensed, and so there's no vested interest in them trying to come to the department, and so a lot of those are default orders. But the ones that we find that are against licensees, they end up paying those and taking care of those fines. This year, these statistics are through April of this year. As you can see, we've opened 1,600 new cases, so we're kind of right on track of where we were with the number of cases that we're getting year to year. Resolved 1,500 of those, so that's kind of still on that same track. This year, we've assessed about $600,000 worth of penalties and collected about almost $100,000 worth of penalties. That's what I have for you today. If y'all have any questions, feel free to answer them.
Any questions by the advisory board concerning the enforcement division report? All right. Thank you, Mr. Medlock. Moving on to item F4 is the Education and Examination Division. At this time, the chair recognizes Mr. Ray Pizarro.
Good morning, Mr. Chairman, members of the board. Welcome, new members. My name is Ray Pizarro. I'm the director for the Education and Examination Division. For the purpose of the new members, I'll kind of give you a little brief overview of who we are and what we do. The division was created back in 2004, and what we do is we oversee the approvals of CE courses, the providers, the approvals of schools and their curriculums, the administration and development of the examinations. There are industries that require an exam component to obtain a license, and we oversee those examinations. And we also oversee the inspections of the education providers, the schools. And we also do audits on CE providers, the courses, and online courses. That's kind of a gist of what we do and who we are. In your packet, you'll see a lot of different key statistics. This board has previously requested different methodologies on viewing the statistics, so you'll see them there. Just keep in mind when you're looking at the stats on the pass-fail rates for the new members, those are pass-fail attempts. They're not people. It's how many times the exam is taken. It's not how many times a person has passed or failed. So just keep that in mind. I want to give kudos to the SME guys, our subject matter experts. These folks are the ones who sit days and grueling days looking at items, looking at the poor performing items and what we need to do to change and what things we need to have on that examination so that the department can administer an appropriate test so that we can make that assessment prior to issuing a license. So the exam is critical. This coming September 1, the exam, all exams will be now based on the 2017 National Electrical Exam. And we say that, we have that out there, we have to adopt it every 3 years, and we do tell the candidates prior to them testing, there's a little screen they'll see and they'll say this exam is based on 2017, so that they understand. If they have an old NEC code, it's the questions are going to be based on that new code, and because the exam is an open book test. Also starting September 1, we are launching a different face, if you will, for the Master Electrician exam. You guys got a copy of that. We sent you the copy of the CIB, what it looks like. I just want to, in public, I just want to tell everybody, the exam is not changing. It's just how it's being delivered and administered. The SMEs thought it will be best for the candidate themselves, so they're spending a lot of time on calculations, and some of these candidates are losing time and not being able to finish the exam. So you get a little bit of both. So what we've done is we broke it up in portions. So you have an NEC knowledge portion and a calculation portion. The cost is still the same. The time on the exam is still the same. It's broken up. It's just broken up into portions. They can take both portions at the same time when they first take it. If they fail a portion, they just have to retake the portion they fail. And the cost of the exam remains the same. So all that's in the candidate information bulletin. I just want to make sure those who are listening, they don't have to, and it's already posted in the CIB. We always give people ample time so that they can see what's going to happen. Here's the new CIB. Here's the new layout of the content outline. Here's the whole layout. We just want to make sure you don't have to rush and go and take the exam today. It's not a change of the test. It's just a change on how it's being administered. And as you heard Brian Francis talk about HB 1698, we're going to be working on that as well. So we're going to get the guys back together, and we're going to have to develop a journeyman industrial license examination. So that's going to be another big task for us. I think at this point, that's really all I have for you at this moment. We are, the department, our division has grown tremendously, Mr. Chairman, since last week we saw each other. It's the responsibilities we have has increased. As you heard, these transfer programs from Phase 2 that are coming over from the Department of Self-Aid Services, 5 of those programs are going to require an exam component. So we're going to be working with those and handing those off to PSI so that they can deliver that exam. For the new members, the agency, the department administered at least about currently over 60,000 exams a year, and that number is just going to increase as we continue to take on new programs. That's all I have for right now. I'll be happy to answer any questions if you have any.
Okay. Any questions by the advisory board concerning the Education Examination Division report? Ray, I want to go. I'm sorry.
I got
Go
one
ahead.
quick-
Yeah,
yeah,
go,
one
Mark.
question. Just a clarification. We discussed it, but we hadn't met in a long time, and a lot of water's gone under the bridge. Clarify for me again, especially for the benefit of the new members who carry licenses. When you participate as a board member in the examination development process, it has an effect on your license. In reciprocity, there was some effect on it. If I remember.
Participating as an SME?
Yeah.
No, there's no effect.
If you're a part of examination development, it doesn't affect you?
No.
Okay.
No, it's, we tell folks that, the only thing I can think of, maybe what you're thinking, if you have a license, for example, let's say you have a master electrician license, and you're looking at the maintenance electrician license for whatever reason, you're participating on that, and you want to get your maintenance electrician license, which you're more likely not, you wouldn't be able to do that because you've looked at the questions.
Right.
So there'll be a period of time where you would have to sit out. But that's disclosed, of course, up front to everyone. We don't have that problem in this board. There's other boards that we would have that issue because of the potential cross that this person may go and take this license, and that happens in the air conditioning contracting license. There's that potential that the B license and the A license, they might want to jump around, so that's disclosed to them up front. And so some of those folks make the decision, well, am I gonna get it? No, well, I'll participate. If I'm not, I'm out. But there's not effect on your license per se.
Okay, I remember.
Now, if you don't know the answers, we might take your license away. No, I'm kidding.
Hey, at my age, you can have it. Okay, all right.
Mark, I think what you're referring to is a discussion that was had that, somebody, let's say for instance, you passed the masters at Houston, and so you grandfathered in when they had the state license.
Right.
If you participated on the master exam development, and for whatever reason you wanted to break down and take the state exam so you could reciprocate somewhere else, you couldn't take that exam.
That's what it
because you
was.
participated as a
That's what it
subject
was.
matter
Talking about the
expert
rest, right.
on
Yeah.
that masters, and I
That's what
think
it was.
that's the discussion we had.
Okay.
So, yeah. So if you want to take the test in the future, do not be the subject matter expert on that test, bottom line. So, great. I had one question, Pizarro. When will the test that you're administering, once we adopt the 2017 NEC, what's the first date that the test will actually incorporate the 2017 code changes?
It will be on September 1.
September 1?
Yes, sir.
So you've already developed the test?
Yes.
New test based on,
Let's be clear, it's not a new test, but what we've done is we've referenced all the items to the new code.
got it, understand.
I don't want to scare anybody.
All right, thank you for that.
Yes.
So September 1, 2017.
Yes, sir.
Thank you. Any other questions? Mr. Pizarro, thank you for your time, Ray.
Thanks, Ray.
Moving on to F5 is the licensing division. At this time, the chair recognizes Ms. Lisa Hodak.
Good morning, Chairman, board members, and welcome new board members. I'm Lisa Hodak, the licensing manager in the licensing division. And my report basically has all the different individual as well as contractor licenses. And I have the new licenses issued, renewals, total population, and of course the percentage of renewed online. This is my standard report that I give at all of the advisory board meetings. I tend to give the last 2 to 3 years just so you can see the difference between the last few years. Overall, we usually always see an increase in this population, in this industry, which also keeps us pretty busy. I also want to reference at the end of the report where it has combined. I have facility licenses issued as well as individuals. The facilities that are referenced refer to the business licenses, which for this industry is the contractor licenses. And again, as you can see, in regards to the combined, over the last 3 years, in fiscal year 2015, we were at just over 129,000, and now the third quarter of this year, we're at over 143,000. I will, of course, eventually add the journeyman industrial electrician license once we start licensing them, which will be next year. They will be added to this report. And my group processes all of the licensed electrician applications. And that pretty much concludes my report. I'll be happy to answer any questions that you may have.
Any questions concerning the license division report? I've only got one, Ms. Hodak. When you say new license issued, that would be an individual that's never held that license before?
That's correct.
Correct.
Yes.
All right.
For that specific license type, yes.
Right. Okay.
'Cause,
So an increase of 27,000 apprentices, or 23,000 year-to-date, would be people that have never had an apprentice license before?
That's correct.
Okay, great. Same way with any of the rest of the different licenses?
Yes.
Great, thank you. Any other questions? All right.
Thank you.
Lisa. Moving on to item G is discussion and possible recommendation regarding the adoption of proposed rule amendments to the 16 Texas Administrative Code, Chapter 7.3, 7.3.100, and the public comments received. The proposed amendments adopt the 2017 National Electric Code as approved by the National Fire Protection Association on August the 24th, 2016. At this time, the chair would recognize Mr. Doug Jennings, our General Counsel. Mr. Jennings.
Thank you, Mr. Chairman, board members. As many of you know, and some of you may not, oh, by the way, sorry, for the record, Doug Jennings, Assistant General Counsel for the department. As many of you know, Section 1305.101 of the Electrical Safety and Licensing Act requires the Department of Licensing and Regulation to adopt every 3 years the revised National Electrical Code. And we've already gone ahead and taken the steps, and you've heard it mentioned a couple of times today, to adopt the 2017 NEC. And so what you have before you in your materials is a rule, Rule 73.100, which was published in the Texas Register on May 19th of this year, and the deadline for public comment passed on June 20th. We received one comment to our rule proposal, and it is not really at all relevant to the rules, so there's no need to discuss it. But what we are, this is a little interesting. Normally what I will do when we go over rulemaking is I will ask for your approval to move forward with a rule. This is a little bit different. We have a statutory directive to update the NEC. So we're happy to entertain any questions about implementing that. As you know, we've got an effective date of September 1. I'm happy to answer any questions about the process. But as far as we'd love to have your formal approval, if possible, to move this toward the commission. But just being realistic with you, the board today doesn't, whatever your determination, we still have to press forward with it because we have an obligation under the statute. The next rule I'll be presenting to you, entirely different. That is very much within your power to give the yay or nay to. But I would, if you have any questions, we've got some folks on hand that can answer your 2017 NEC questions.
Thank you, Mr. Deans. Any questions by the advisory board concerning the recommendation and statutory requirement to adopt the 2017 National Electric Code? Hearing none at this time, Chair to entertain a motion.
Mr. Chairman, Mark Roach, so moved.
Motion, Mr. Roach, sir, second.
Mr. Chairman, John Sparrow, second.
Got a motion, second by Mr. Sparrow. Got a motion and a second. Any discussion? Hearing none, call for the vote. All in favor say aye.
Aye.
All opposed? Motion carries. Moving on to item H is discussion and possible recommendation regarding publication of a proposed rule amendments to the 16 Texas Administrative Code, Chapter 73, specifically 73.26 regarding verification of on-the-job training. This time, the chair to recognize Mr. Doug Jennings, our General Counsel. Mr.
Thank you
Jennings.
again. Doug Jennings, Assistant General Counsel for the department. The proposed rule that you have in your materials, Rule 73.26, deals with documentation of required on-the-job training. As you know, particularly in the realm, I guess, I'll just give some examples of a journeyman electrician applying for an apprentice, someone who is currently an apprentice who would like to apply for a journeyman license has to verify that person has met certain thresholds for on-the-job training. And so the way that we handle that is they will file their application and we ask them to provide some proof that they have put in this number of on-the-job training hours. And part of that is, we can ask for documentation of pay stubs, W-2s, things like that, but there's also an experience verification component where a licensee, a master sign electrician can verify the experience. This person who is applying for the journeyman license, yes, I verify that they performed X number of hours of on-the-job training in the past year or 2 years, what have you. So the rule that you see in front of you looks like it is a drastic departure from what was before. You see a lot of underlining and a lot of strike-throughs. Honestly, it's not. Subsections A and C, we really just tried to reword to make it more readable for just your average person looking at these rules. One of the things we try to do at the agency is when we're drafting rules to take a plain talk approach, just so it's very clear what it's saying. And we felt like A and C read a little technically, and we wanted to remedy that. But the reason this arose is subsection B. And the current subsection B says that a master electrician or master sign electrician shall provide verifiable documentation of on-the-job training hours of an applicant they have supervised upon the request of the department. And so the standard the practice right now is if our department gets in touch with you, if you're a master electrician or a master sign electrician, and says, hey, we've got this applicant who says they worked under your supervision for X number of hours, please supply us with some verification or some documentation regarding that. So that's our current process. So what B does is just puts a timeline on that. It doesn't really change your obligations or your duties. One of the reasons we're doing this is just we have, in some of our other programs, I'll just use our air conditioning and refrigeration program, for example, since I've also worked closely with that program. For one reason or another, we have a licensee who won't want to sign off on the experience of an applicant, whether it's bad blood, whether it's, maybe they have a feeling that the person doesn't, maybe there's something questionable about their behavior or character, or frankly just doesn't have any knowledge of that particular project or that experience. And so what we've done for that program is just put in basically what you're looking at here, a rule that says, if the department contacts you or the applicant, him or herself, contacts you, give you a timeline. So you know kind of what, I work better with deadlines. Anytime anyone asks me to do something, I say, when's it due? I need to prioritize. And this really will give us some guidance and give licensees some guidance on when that verification of experience is due. I've talked to some staff, and I talked to Mr. Bell the other day about this, and we've seen that maybe 15 days. I'm not sure. It's up to you if 15 days is a workable timeline for your industry. If not, we're flexible. So 15 days is too soon. We're happy to work with you to expand that, certainly. But one of the key things that we want people to know in all of our programs where we have a rule like this is that no one is going to be required to sign off on any experience they don't have any knowledge of. If you don't have records, of the applicant performing the work, or if you didn't personally supervise it, and you just don't have any knowledge, and there's no way for you to have knowledge, we're not going to ask you to sign off on that experience. So there will never be a case where anyone should feel compelled to sign a document verifying someone's experience if they really know that they can't do that, honestly. And so that's one thing we try to make very clear in this. Because, there are just some concerns. People don't want to feel compelled to sign a piece of paper where they're swearing by penalty of perjury that they know something. They don't want to feel compelled to do that if they don't have the knowledge. And so that's a very important component. And that is, we've put that in subsection B. The licensee must provide the verification within 15 days. The licensee must verify only on-the-job training within the licensee's knowledge. But with that, I'm glad to answer any questions that you might have about our proposal.
Mr. Jennings, John
Yes.
Lewis. I have a question. Is it true that if somebody's on the job training, they have to hold that apprentice license? Say they're working towards their hours. Is it like if you're signing off on them, you have to also go back and verify that they held that apprentice license as well?
I'm going to ask our department for some help on that question. Does anybody? I guess the question is, does the licensee have an obligation to verify that the person is holding a license?
Yeah. So if I sign off on somebody's being a master, I sign off on somebody's hours of, say they worked for me for 2 years, and it's 4,000 hours, and they only held the apprentice license for half that time. So am I signing off on the 4,000 hours or just the 2,000 hours?
Anyone want to take the mic?
I'll start.
Thank you.
Lisa Hodak, licensing manager. If I'm understanding your question, so if a journeyman applies,
Let's say somebody's applying for a journeyman's license, and
Okay.
they're holding I'm signing off on their apprentice, basically their apprentice hours.
do they have, and your question is, do they have to hold an apprentice license?
Are they obligated to hold that apprentice license an entire, is it 6,000 hours to get to journeyman's, is that
It's
correct?
8,000.
8,000?
Okay, so the answer to the question is not really, if they're applying for the journeyman
Right.
license.
As long as somebody like myself has signed off on it.
Right.
Okay.
However, on the other part of this, I think, David, we might refer to you, everybody should hold an apprentice license.
Sure.
So, David, if you want to add to that.
So David Gonzalez, Compliance Division. Everyone has to have a license to perform electrical work. When it comes time for licensure, our staff cannot verify experience for every single individual application that comes in, so there are going to be applicants that if you are verifying their experience for 8,000 hours, they're probably going to end up being able to sit for the journeyman exam. But the individuals that are out there, if they're found during a license sweep, or any individual found in a local jurisdiction not holding license and doing electrical work, they should have an apprentice license in hand. If they do not hold an apprentice license in hand, they're in violation, and a complaint would be filed and opened in our enforcement division.
Right. So I guess going back to my original question is, it's not necessary that we go back and verify that they held that apprentice license.
I believe that is correct.
But if we know
And-
that they did work the 4,000 hours, it's okay for us to sign off on that?
Yes, and if that's within your knowledge, and this rule doesn't change your obligation there. Really, this rule, is just providing you a timeline, providing both the licensee and the department with a little clearer time frame. And yeah, you've obviously hit upon an area of confusion. We don't like to take the mic and say, no, a person, in theory could perform electrical work that you could verify if they didn't hold a license. It's a very sticky issue for obvious reasons. And we like to be aware if that's happening, so we can police
Right.
it.
I've had a number of people ask me to sign off on those things, and that
Right.
was a question I always had about that.
But, and that is something we can continue that discussion. I'd be happy to kind of meet with our folks and kind of figure out if we need to take some direction on that, for the next meeting, because it's a tough thing. It really is. And we don't want to, we know the licensees are dealing with busy timelines, busy work weeks, probably don't have the time to go, do a bunch of searching through government records. So we tend not to think that you have, the law doesn't tell us that you have an obligation to investigate, but at the same time, it would be good to know that the people performing the work are properly licensed, certainly.
Thank you.
The risk, Keith Bell, the risk you run in is if they're working for you, then they have a license, or you're gonna be held accountable in the event you have a license sweep and they find you're not. So it is, may be sticky on the license part, but it's not sticky on the enforcement part of it. That's a risk that you run. And who gets held accountable is the master, not the contractor or the apprentice. So, for working.
Mr. Chairman, question.
Mr. Roach?
So, let me understand, make sure I understand what you're saying. Say I was an apprentice, and I held a license for a period that could be calculated to be half the time of the number of hours required for me to move up to journeyman. Okay, I mean, you can go in and say, when do we have record that he had an official apprentice license? Okay,
Right.
and somebody's verifying that I have the hours required to sit for the exam, and you do the math, and you say, well, how did that happen? You only had a license for half of that period.
Right. I understand the question. I mean, and this is something that we have dealt with internally, and we have differing opinions, frankly. And I think that it just depends on the perspective. I'm taking no position here. I think that if you were looking at this question purely from a tabulation of hours worked standpoint, and not trying to put an obligation on the licensee to go verifying licensure of that apprentice or journeyman, that is one thing. I think, and the other is whether a person is performing unlicensed activity. I think the real problem arises for the applicant when we become aware, when we do that math and say, oh, so you were only licensed for 2 of those 4 years. To me, that appears like a very good reason to open an enforcement case. And so, but we don't have a policy in place that says, in this scenario, that that those hours cannot be counted toward the person's experience if they didn't hold a license at the time. We do have a rule or a statute like that in some of our other programs. We have seen that, and it's tough to name them offhand. I think maybe cosmetology might have it explicitly, where you may not accrue hours unless a license is held. And so we've touched upon something that we have some work to do, perhaps. We're not clear if maybe that's a statutory change that needs to be made, or if we can address it by rule. David?
And just one more item to consider. There are so many exemptions in the electrical statute that the individual can be working under. It would require making sure that we go through every exemption, that they may have earned their experience under someone that actually held a journeyman license. So it has become a complex matter to address, but definitely something worth discussing.
So,
Miss,
John Lewis, so we're
John,
basically.
John, hang on a second. Stacy's got a comment. Stacy?
Is the check only on number of hours during the apprenticeship, or is there also a check on duration to make sure that a certain number of a certain time has elapsed between your apprentice licensing?
What we do in licensing, for instance, if someone's applying for a journeyman license and they have to have 8,000 hours. So we look at, do they have the documented 8,000 hours under the master? That's what we look at. Now, he should hold an apprentice license, should. But the way the law reads is that they have to have 8,000 hours earned under the master. So that's what we're looking at. Is the application complete? Whether he holds an apprentice license or not, you know, that's another issue. But we're looking at the documentation. Is it verified? Does that answer your question?
So last point I was gonna make, basically it boils back down to whoever the master that's signing off on that, it boils back down to their integrity, that they're verifying. I mean, you're signing off, you're putting your name on there, you're verifying that those people worked under your authority in that time. I think if it goes back to that, I mean, it kinda covers it.
That's
you know.
correct, yes.
John, will you state your name? Anytime someone
John
speaks,
Lewis.
if you'll be recognized by the chair and then speak your name, then for the public record, then everybody knows who's speaking. If they're listening to it
New guy.
on the radio. Mr. Rhodes, go ahead.
Mark Roach. So Doug, let me make sure I clearly understand this. What you're telling us is the law is silent.
I believe, on this particular issue, I believe there is no provision, of which I am aware, having looked at the statutes pretty intensively, that a person may not accrue any sort of experience for purposes of licensure.
Gotcha.
If the person is unlicensed. And that is something that does appear in some other statutes. And you know, I think part of that maybe is in recognition of the difficulty that we might have processing it. You know, like Mr. Gonzalez said, you know, having to research whether the work was exempt or not. But obviously problematic. I mean, there's no question about it. I don't relish being up here and having to make that statement that potentially someone could get a journeyman license.
I live by an old rule. If it ain't in black and white,
Mhm.
you can't enforce it.
Well,
Fortunately, that's a fact.
But you know, once again, I don't know how much of a practical problem it is because of the fact that in the scenario that you gave us earlier, where we know that someone was licensed for maybe 2 years and was engaging in unlicensed activity for 2 years, you know, we have grounds to move against them there if they weren't performing, or at least to open an investigation and find out whether or not they were performing exempt or non-exempt work. So it's definitely risky from an applicant standpoint to submit that application that says, I wasn't licensed for 2 years.
Mary
Jennings, I've got a
Winston,
question.
if I can interrupt really quickly, Mary Winston, TDLR. I think the question or reason for the question for Mr. Lewis is, am I responsible for this guy who wasn't licensed? Am I responsible for his misstatement, lie, what have you, when he worked under me? You're responsible for the hours that he worked under you. The onus is on you because you're signing off on your knowledge of those hours. Now, the onus is on that licensee for his communication whether or not he was licensed or not. So it's not 100% clear. It's going to definitely be a case-by-case basis. You've given us some more things to work on. But if you're signing off on those hours, all you're required to know is that they did those hours for you. Now, our licensing division compliance will go into, was it exempt, was it non-exempt? We'll figure all that out. you're signing off on, I know this person completed those hours.
And I would agree, Keith Bell, with that statement. It's incumbent upon the master electrician running the company, whether it's signed or not, or regular contractor, that everybody working for you must have a license of some type. If you don't do that, you'll be held accountable. Now, here, this question may be for Mr. Medlock, but in that scenario where an applicant fills out a journeyman's license and he has something signed off from a master for 8,000 hours, and through this process, you determine he only had an apprentice license for 2 years, and you can't qualify the other 4,000 hours, whether it was exempt or not exempt, when you open up that case, is that fraud been committed by the applicant and the master that signed off the 8,000 hours when he didn't have a license? If in fact that person maybe didn't work but 4,000? That'd be my question. And I think that's important for you to discuss for anybody that's listening to this process, though we do have a workforce shortage, that we're just not gonna circumvent and short-circuit the process of 8,000 hours.
Absolutely. Specifically, with regard to the applicant, if they're putting false hours on there or making any kind of, fraudulent statement with regard to that application, absolutely, the department will go after it. Actually, that was one of the cases that I highlighted, that the master had actually put work on there to qualify for the master's, to take that master exam, which he did, but then in reviewing, because he had done some other bad work, we went back and reviewed and found that, well, that company that he claimed he had worked for didn't have a master electrician license under it, and so all those hours didn't count. So we went back and, with that case, revoked that. So in that case scenario, where an applicant does, put, I worked, 8,000 hours, but only 4,000 were under, as a licensee, then yes, we would go after that person. Now, you're right that the master is responsible for employees that the work that they do are having license. So if it can be determined that the master had knowledge, which is kind of a high burden to go after, and that they allowed someone to work, and if we have specific information that that person from that, let's just say it's 2010 to 2014, but the first 2 years the guy was unlicensed, and then the next 2 years he was licensed, and he's now making his application for a journeyman. If we have specific information for that first 2 year period, that the guy was under his employment and he did work, and we can prove that, then yes, we can go after that master for that work of allowing that person to work as an unlicensed person.
And so really you got two different opportunities. Either you prosecute him for working someone that's unlicensed, or you prosecute him because he fraudulently gave somebody hours that they didn't work.
Correct.
So you've got two avenues there in that scenario.
So, Mr. Chairman, John Lewis, that goes back to my original questions. I need to go verify that they had their license.
And a lot of times it's fairly simple, because the website, if you just go to TLR website and type in the person's name, because we have a way to look at it, they should be able to come up real quick, whether they have a license or not. So it's not, you don't have to make a whole bunch of phone calls.
But does it tell me when they I don't know if you noticed, but people are totally forgetful, and some of them may or may not be employed by me, but they forget 1 year to do their apprentice license.
Right. No,
So I know it's incumbent on me to make sure that they've got it, but,
I believe, I'm not 100% clear on it, but I believe the website just maybe shows whether or not their current license status is and when it expires.
Doesn't tell you
It
their
doesn't go all
history.
the way back. The
so-
department carries that information, but yeah.
So do I need to make a phone call whenever I get ready to sign off on somebody's hours?
If there's a doubt, it wouldn't hurt. But at the same time, there's also a
Got
section,
real
I believe, in
painful.
the form that says other, like, at least in the AC world, because it's the form I'm most familiar with, because I've recently actually done a few of these cases on this specific topic, and it has check boxes, it's like, oh, this person did coil cleaning, he did duct work, so on and so forth with regard to the AC program, and I think the electrical field will probably have something similar. But there's a line section right below that for other, like what other types of work that you did or did not perform. So in that section, you could possibly put in there, he worked for me from this time. I believe he was licensed throughout the whole time. I'm not sure about, certain dates, or, just explain yourself, because at least that way you've put the department on notice. Maybe we need to go back and look before we issue this person's, ability to go take this license. Because I know a lot of times, at least in the AC world, that was kind of the hesitancy. It's like, one case in particular was that the AC contractor was in a different city than where the applicant was. And he's like, I know of him, I know he worked for this big company that we all worked for. I don't know what work he did, that's why I didn't want to sign the form. When I gave him a call, he told me that story. I was like, well, put that in that little section, you know, he worked over in this other point. I don't know what work he actually did for those people. So, and then licensing will reach back out to the applicant and say, okay, well, sorry, you're gonna have to give us something else, or give us another name of, you know, maybe a more direct supervisor. So, that's what that little extra section is for, on these forms, so that in situations that, you know, we're not sure about, we can maybe give us some more information so that we can go do some more research.
Any other questions?
Chairman Bell?
Yes, sir.
Randy Paul McCall, just to be clear that when this rule change takes place, is there another place in 1305 that says who is authorized to document these hours? Is there another place? Because you scratch through it in this, where it's master electrician or master sign. Is there another place in 1305 that does say that, David? I mean, I don't have it in front of me.
To the table, David.
Let me find it first. This is David Gonzalez, Compliance Division. In the statute, under the maintenance electrician, residential wireman, residential wireman, they're also authorized to verify experience. Those are specific to statute in another portion of the statute. Let me look it up if I can find it for you, and I can give you the reference, or I can give you the reference afterwards.
Just want to verify who is authorized to provide this documentation, that's all.
Gotta love technology, and the phones give me all the access, but it's a little tiny.
Are you looking for 1305?
Got
We've got
1305.
copies of it up here in our packet.
Hey, that makes it easy.
We heard it's 1305.153.
Just happen to have a copy. I need that
Yeah,
back, David.
150, through 150, 160, 160 requires all that, correct?
You're correct, sir. David Gonzalez, Compliance Division. You're correct, sir.
I'll read it right quick, sir, Bale. No, under 153, 1305, 153, master electrician, must have at least 12,000 hours on the job training under the supervision of a master electrician. It does not say who can sign off on it specifically. It just says they have to be underneath a master. So, a master electrician may verify compliance on the job training requirements for issuance of a master electrician, master sign, journeyman, and journeyman sign. Under journeyman, must have 8,000 hours under the supervision of master electrician, and no one else is given the ability to sign off on the documents.
Residential wireman is under 157.
On 150 what?
Under 157, residential wireman.
Yes,
supervision.
or a residential wireman.
And
That's
then
the only place
and
that
then
allows
158
someone.
under maintenance electricians. So it's, yeah, broad but unique, if you will, under 157, 158, and then master sign have that authority as well.
So nobody but a master can sign off on a journeyman exam. Bottom line.
Bottom line.
Good.
Mr. Chairman, Doug Jennings, Assistant General Counsel. One of the reasons we actually changed that language was to account for changes to the statute, just so that if a new class of licensee is added to the statute, for example, we wouldn't have to just immediately go and change the rules. And so anyone who is authorized by the statute to sign this document must follow this process. We just, just kind of a streamlining. But yes, we do need to know who is in fact authorized to do those things. and our licensing and compliance divisions have a good handle on that. But from a rule writing standpoint, we changed the language to give it some flexibility.
Thank you.
Mr. Roach, you have a comment a while ago? I didn't mean to cut you off, but Mr. Paul McCall was right in front of the buzzer.
No, I think that maybe this is an oversimplification, but signing off on this stuff is kind of like co-signing a bank note for somebody. If it's one of your offspring, you don't have an issue with it, but if they're not your offspring, you probably want to know everything about them. Birth certificate, medical records, and a note from their mother.
Thank you. I would just want to, for clarity purposes, Mr. Jennings mentioned a conversation he and I had, and we're still debating this issue, but, you know, the industry has been at an onslaught of staffing agencies that have entered the electrical contracting industry. It's therefore, you know, if we go out here and have a staffing company furnish temporary electricians, they may work for me one day and they may work for me for 6 months. Now, they're not my employee, so I'm not keeping detailed payroll record of how many hours or days or whatever they work for. I'm paying someone else and they're on their payroll. So my only concern, and this is the reason, and I appreciate Mr. Jennings' latitude, if in fact I'm working a temporary and I'm the master, because these staffing companies don't have masters working for them. So that individual is going to reach out to my company and say, I worked 10 days for you, or I worked 100 days for you, or whatever the case may be. I'm not going to have any of those detailed records to determine that, because I don't have anything with that guy's name on it. So, you know, I've got to reach out to the staffing company, and then they're going to have to prove to me before I can fill out this document. Now, I'm not going to not do it for that individual once I qualify, and the same as you. I'm not watching that guy do the work. I've got 250 electricians working for me. So, unfortunately, I probably couldn't even name most of them's names, you know, but once again, I've got to go back to the staffing company to qualify that individual. Well, now, if I'm going to be required to give you verification in 15 days, now I'm relying on the staffing company to pull that documentation, because these guys are transient. The reason they work staffing companies, the next staffing company tomorrow that offers them another $1 an hour, they're at that staffing company. So, you know, I mean, you can have 3 staffing companies and have the same guy work from all 3 of them over a 6-month period. And so I would just respectfully think that 30 days would be more reasonable. I know someone's trying to take an exam, I get that, but, you know, if they've chose to earn their experience through those type of mediums, then I just don't want to be the master that you're calling and saying, you know, how come you unwillfully provided this information when it's out of my care, custody, and control, because they're not my employees. So that would be my only comment concerning this. Otherwise, you know, I agree. I mean, people need to be able to verify their employment, and, you know, and for so many times this is personal. It's not, you know, based on being a professional. It's just I don't like them, or they left, whatever. So, and we shouldn't withhold their ability to be able to gain licensure. So. Any other
Chairman Bell,
questions? Yes, sir.
John Sparrow. Mr. Jennings, you mentioned earlier, and I know the 15 days, and it's kind of a double-edged question, really. If a master electrician refuses to respond, or there is some bad blood type of environment existing, are there other alternate methods of compliance that the applicant can pursue in order to show, you know, compliance within the hours?
I believe there are, and I might ask Lisa to rejoin me. And she's here already, so ask the mic.
Yes, basically, we already have this this is Lisa Hodek. We already have this process in place in air conditioning, and that's also one of my programs that I work with, and it seems to be working well. Basically, we contact in this case, it'd be the master electrician, and we would email him, we would call him, we would also follow up with a written letter saying, you know, John is saying that he worked for you. Did he work for you? What kind of work did he do? When did he work for you? I believe we give them 3 attempts, and if we still don't hear from him, then we will file a formal complaint. and then our compliance department will take it over from there, or enforcement department, I'm sorry. We'll take it from there.
Okay, thank you. And then my other comment on the 15 days is, you know, most electricians are doing pretty well right now, and they tend to take long vacations, so 15 days may be a little short.
Duly noted.
Thank you.
Any other questions concerning 73.26, the documentation regarding verification of on-the-job training?
Mr. Chairman, Mark
Yes, sir.
Roach. Actually, I'll direct my question to Randy. Did you get your question answered?
I did.
Okay.
All right. Any other questions concerning this? If not, the chair would entertain a motion.
If I may pipe in for just a moment,
Sure.
Judge Jennings. Assistant General Counsel. The motion, I guess the action that we are asking you to make today is to recommend the publication of this draft rule, which, as you know, will give a public comment period of 30 days. At the next meeting of this body, we will bring the public comments that we've received to you, and then at that point, you will either recommend or not recommend that we move the rule to be adopted by our governing body, the commission. So, but today is for publication.
Chair at this time would entertain a motion regarding the publication of the proposed rule amendments to 16 Texas Administrative Code, Chapter 73.26.
Mr. Chairman, Mark Roach, it would be appropriate, Mr. Jennings, at this time to also recommend the 30-day.
Yes, I
could
believe that's
modify.
correct.
Okay.
So the motion would be to.
So
adopt
moved with a 30-day.
With a 30-day, okay, in
Modification.
subsection B.
We have a motion to, regarding the publication of proposed rule, and then with an amendment to 30 days, calendar days of the request. Is there a second?
Mr. Chairman, John Lewis, second.
Got a motion, got a second with Mr. Lewis. A motion and a second, any discussion? Hearing none, call for the vote. All in favor say aye. Aye. All opposed? Motion carries. Thank you, Mr. Jennings.
Thank you.
And Ms. Hodak and Mr. Medlock, we had quite the discussion going on this matter, and Mr. Gonzalez. And I appreciate your approach of being a straightforward approach, writing your rules. Your predecessors could make you dizzy with the legalese they would put in these rules. Matter of fact, you've had 3 predecessors during my tenure, so yeah, that you could be dizzy just trying to read it. So thank you for that. We appreciate it and look forward to working with you.
Thank you, Mr. Chairman.
Yes, sir. Moving on to item I, discussion of the 85th legislative session bills affecting the electricians program, House Bill 1698 specifically. We discussed that, or Mr. Francis discussed that in his staff review. Are there any questions or any additional comments the board would like to make on item I? Hearing none, we'll move on to item J. Matter of fact, I'm going to take K and J out of order, and I'll explain that in just a second. So item K is discussion of a summit regarding the shortage of licensed journeyman electricians and possible solutions to address the shortage. That summit, it will be just like a work group. So when we had our Open Meetings Act training earlier, you can't have a quorum show up at this summit. So it has to be a group that's less than a quorum, like a work group. And so, correct, David? Okay.
David Gonzalez, Compliance Division. Yes, what we'd probably like to do is coordinate the work group first, make sure we got a lot of the issues that we're going to be discussing, and then we'd actually have a summit. I've got some experience with doing this in the past, as well as Mr. Pizarro, who would be participating. We'd have anybody and everybody that wants to show up, so it would be a quorum that could show up, and we would invite the public to participate. We've had the meetings here in the past where we've basically taken the input and identified any of the issues that may be affecting whatever matter we want to discuss. In this case, the shortage of journeyman electricians.
Unfortunately, though, item K doesn't allow us to create a work group here. I mean, that's not, it is specific of J, but it's not K, and that's the reason I was gonna, reason took it out of order is I wanted to ask some of our members here that are contractors to serve on that summit in a process just like a work group. But since it's not posted as a work group, we can't specifically create one.
Mr. Chairman,
but we can move forward with discussing a summit.
What we would done in the past with other industries, we would have the summit, and we have the summit in the form of the advisory board. We will have an advisory board that day, and you guys, Mr. Chairman, will you turn the summit over to the department so that we do have a quorum and it's posted as a public meeting, and we'll basically turn the chairs and have the audience here, and after the summit, we would turn the meeting back over to you and whatever business we have and the advisory board so that all can participate.
Okay. Well, that's great. If we're gonna do that as a summit and post that as a meeting.
Yes, that is correct. And, Mr. Bell, Mary Winston, what we do is we post that summit like it's an advisory board meeting, but we post it in the Texas Register, so we don't have those quorum issues. So we follow those guidelines and timeframes, so we're good. When we have done these in the past.
Outstanding. Well, we've never done one, and I've been doing this job for 14 years, so it was a little odd. And so I just wanted to clarify it before but it's certainly an issue we need to discuss.
And the point to be made, David Gonzalez complies, the point to be made is everyone would be invited, just like it was an advisory board, but if for any reason we didn't have a quorum, the business could still be conducted. The public shows up, we still take all the input. There's no real action other than discussion being happening, and that's what's been done in the past.
My question would be who would create the agenda so that we can make sure that everything is specifically listed to be able to discuss, or is it good enough if you're talking about the shortage of a licensed journeyman electricians and possible solutions is broad enough that we can talk about anything, from licensure to test to hours to SMEs to.
We're already writing down your list, Mr.
Right.
Gonzalez complies.
You can
You're exactly
definitely
right.
make the list. Anyone on the advisory board can provide the questions, send it in to the advisory board's email address, or provide it to David or Ray, just so we can get it all together. But we're not having a quorum situation if you're not huddling as a number of quorum and deciding what you want. And so if you individually provide this list, we may have some overlap, and that's good. That's good. We'll know what the issues are.
Well, let's open it up for discussion then. I just wanted to get that clear because, you know, it kind of almost appeared like a work group, but yet it wasn't posted that way. I didn't want to go out here and start getting volunteers, and then, you know, we just got through with the training. So with that said, I'll open up item K for discussion concerning participating in the summit concerning the shortage of licensed people.
Chairman Bell?
Yes, sir.
Randy Paul McCall. When would this summit occur, or who's going to set the date for this?
David Gonzalez Compliance Division. Typically, we would coordinate with you guys to make sure that y'all can be there, since we want y'all's participation, and then after that, we have to coordinate with all our other advisory board and commission meeting dates as well. What would be your preferred date?
Tomorrow.
Tomorrow. I'm not sure we can accommodate that. Could be wrong. Saturday would be a difficult one for us, but.
Well, when's the next holiday? We could do it on that day. Now, the reason I brought this up is as a contractor, this is a serious issue for us, and developers and everybody is concerned. We grew contractors by 805 members. We grew journeyman wiremen by 590. So I don't know who those 800 guys are hiring, but they're not there. And so it's a huge problem. So I think the sooner we have it, you might want to get through the summer, maybe just get past the summer.
Yeah, we got to get off that 2-week, 3-week, 4-week vacation.
Well,
Who said our general contractors?
That was
we
Mr.
take.
Bell who
Yeah,
said that.
That's Keith Bell, yeah.
Anyway, I don't know, you could throw that out there for a date. Maybe at the end of this meeting, we could talk about it.
David Gonzalez Compliance Division, just as our staff coordinate with you guys for this meeting, we will be looking for y'all's calendars to make sure that we can get everybody's participation and make it convenient for the public to be able to participate as well. If it's going to be busy season during the summer, maybe we give that vacation time and do it a little bit later, but as quickly as we can.
Okay.
Anyone else concerning this issue? In my conversation with Mr. Francis, he indicated it'd be the fall of 17, and based upon the summit would be first, and then we'd have to come back or at that meeting, if it was posted, determine we're gonna have a work group in the subsequent meeting, if you set a work group at the summit, so. And then you're gonna meet again, if you remember the timeline, it was February, wasn't it? We're meeting again February 18 concerning.
Yes.
1698, the proposed rules, so I would agree with you, Randy, it's a huge problem. Matter of fact, I just did some statistics. If you look at journeyman electricians, and assuming, because I had data going back to 2012, based on the apprentices, new apprentice license issued in 2012, or based that population, was 46,000. Today, it's through third quarter, it's 73,000. So that's an average increase over 5 years of about 5,400 apprentices. In 2020, there were 20,000 new apprentice license issued. That's the reason, Ms. Hodak, I asked that question up front. So 20,000 new apprentices in 12, which, so they would only have, assuming, if they had that apprentice license all 4 years to get to 8,000, you had 1,418 new journeyman licenses issued in 16. So only 7% of the population that was licensed the first time as apprentices. Then you go back and look at journeyman. If you look at the 2012 population to the 2016, which is a full years, there were a total of 443, just journeyman. That's a 1.3% increase. But if you look at so if you look at how many people are taking the test or passing, the average, you're passing average 1,400 new journeymen a year. So that should be 5,600 over a 4-year period. But you only increased 443. That means we're losing 1,300 electricians annually, journeymen, either from retirement or get out of the industry, what have you. So that's a 3.8% decrease annually and a 1.3 increase over a 4-year period, which is only, if you look at it for 5 years, it was a 0.5%. So we're losing journeymen at a rate of 3.8% annually than what we're gaining. And I mean, that's what's driving this question. So that's what goes back to Randy's issue tomorrow. Because, I mean, I'm no statistician. I'd have to take a little bit higher level math to determine if you're losing 3.8% of a population in a year, at what point do you have none? That's a little bit above my...
Did pretty good, not being a statistician, to come up with the numbers pretty
So,
quick, but you're right, the numbers are not
That's
going
not
up,
good.
and
So-
the other industries are competing with the electricians.
And so what you have to really determine, the real issue here, is what is the disconnect between the 20,000 apprentices a year? You know, we added 32 new apprentices in 16. What is the disconnect that in 16, only 1,418 of them, going back to 12, ended up getting a license? So what's the workforce development disconnect that's creating this problem? Is it because all apprentices are running jobs today? Because there's no supervision requirement? And you know, what's interesting about this, Mr. Palmacall, you've been there a while, we discussed this issue in December the 4th, 2014. So, I mean, those of you that have been fortunate enough to be appointed to be in a governance position, you need to have the vision to see this as coming. If you deal with it once it gets here, it is too late. And so, so what we need to figure out is what has been our unintended consequence that has created this workforce development disconnect. So I would challenge each one of you to be thinking about that. Whenever we put this summit together, those are the questions that you need to get to Mr. Gonzalez or Delia or Tamala or, someone in the staff so that they can put this on. Not a discussion we need to be having amongst each other, but get that information to the staff, to the department, so that we can have a really, strategic discussion at this summit of trying to determine as best we can what is the disconnect. There's got to be one, because it's an anomaly that we haven't. I've been in this career for 40 years, and I've never seen a disconnect like this. Man, I passed my journeyman's test as soon as I had the required hours to get it, and that's just not happening today. So, any other questions regarding item K before we move back?
Yeah,
to
Chairman
fifth?
Bell.
Stacy Malcolm.
I'm sorry,
Yes,
go ahead.
Yes, ma'am. Ms. Malcolm.
Historically, Keith, when you mentioned that you passed your test the first time, I'm looking at the historical pass-fail rates, and it seems like 6 to 7 of every 10 people who take it fail.
That's right.
Has that always been the case?
Well, and I will give Mr. Pizarro and the Education Examination Division, that was one of the discussions that we had, and I believe it was back in 15, October 6th of 15. We brought this to the table. I presented at the SMEs. They asked me to come to their summit, and I presented. And they recommended to the department to take the cut score from 75 to a 70. Industry, as long as I'd been in it, a 70 was a passing rate. The department had raised that bar to a 75, and we had passing rates in the 20 percentiles. Today, it's 34 to 35%, so it was, it made a significant difference, but, and I'm not saying it's the test. The test isn't too hard. We have to determine a minimum level of competency, and our legislature has said that that is a test. And so, you know, what's reasonable to do that? So, if you don't think his microphones aren't sensitive, that was my phone on silent. So, you know, be careful. You'll be on the next viral YouTube video sitting up here. But with that said, it certainly, I appreciate the department because they recognized this, brought that back down to a reasonable level. It raised the passing rates. We have a secure test. We have a good test. We have a great process and great SMEs that do that. However, something we have done in the implementation of 1365 in the last 13 years has created, you know, and maybe it hasn't, but maybe it's just the public, maybe it's just the electricians, but certainly there's some kind of workforce development disconnect, and it's incumbent upon us, if we're going to serve the state of Texas, to determine and try to find what that is and to see that that gets fixed.
Chairman Bell, John Sparrow. I think something for the board to consider for the summit is in the 2015 legislature, the law changed where school leavers could take a vocational route as opposed to a college-ready route. And it's been a little over 2 years now since that changed. And I think my question really is what is the electrical industry doing to target school leavers who are taking a vocational route? Because I see a lot of other industries as a builder and a developer, I see other industries targeting these school leavers and snapping them up pretty quick. There's a lot of educational opportunities for kids, you know, in high school. I have 2 kids in high school myself, and I see it, that they target these you know, young men and women and get them interested in a certain industry. And unfortunately, and maybe it's just, you know, the micro market that I'm in or the small community that I'm in, but I don't see anything from the electrical industry that kind of tries to get that interest. And there's a lot of kids, or you know, young men and women who would really, you know, I would think be interested in this industry because this, you know, the success rate, if you get it, is pretty good. You see plumbers and HVAC and mechanics and welding is, you know, taken off in a huge way for young school leavers, and you know, maybe that's something to consider, and how we can improve the amount of folks that get, you know, that have the ability to enter this industry and increase the workforce. So.
Ray Pizarro, Director of Education. I don't want to get off topic, but just to let you know, there have been ideas within the department. Some of them are possibly putting some key questions on the application to see what kind of education these folks are going through. Then we can compare that education to the exam pass and fail. But we're not there yet. But these are some of the things we need to bring up at the summit.
Sure. Mr. Roach.
Mr. Chairman. Mark Roach. Mr. Sparrow, that right there, that's House Bill 5 that you're referring to.
Correct.
And that is an excellent point to put on the summit agenda. What is the industry, the electrical industry, doing to pursue vocational education, pursue the students in the vocational education process?
I agree.
Because you hit the nail right on the head. Everybody else is chasing it.
Everybody is. There's a lot more qualified, Mr. John Sparrow, there's a lot more qualified students out there who don't want to take the college-ready, route, and they're ready to enter the workforce at 18 years old and work very hard to, develop a good career. So I agree with you.
Keith Bell, those are great comments, and some of y'all may not know this, but I've been on a school board for 20 years, and I've been a board president 14. So, with House Bill 5, and I believe that was 3 sessions ago. Two.
Yeah.
So,
Last session.
four
Last
years.
session.
4 years, I believe, but what had to happen, House Bill 5 gave the TEA latitude to be able to have career and technology education offset some of the requirements of the 4x4. Because from a public policy, we'd spent about 2 decades herding every kid to college. Well, the problem is, it's like a tennis ball and a snake. I mean, it takes a while for it to go all the way through the snake. So you got House Bill 5, and then it took 4 years for the TA to figure out how they were going to implement that. Now it's come to the school levels, and you're dealing with 2 decades of school people that, I was a product of school to work and a career in technology education, electrical training like you're talking about. Well, that all went away. It has been gone for 2 decades. There's nobody in leadership in the school business that, number one, either went through it, or number two, knows how to implement it. And so now you've got the associations, and we'll talk about all this, but it is occurring. The problem is for instance, in Forney, we're starting an electrical training next year in Forney. It starts out with freshmen, so it's 2 years before they can even go to work. And now you've got the disconnect today of OSHA that says you can't climb a ladder, you can't use a tool, you can't do anything until you're 18 unless you're in a not an apprenticeship program, but it's I'm trying to think of the word I'm looking for, an internship. If you're in an internship, you can do a limited amount of that stuff. So now even our apprentice associations, for instance, IEC, is trying to figure out how to sort this out and create internships with you as an employer, so that you're not violating OSHA trying to work a 16-year-old out here trying to teach him how to do this work. So we've got all these hurdles that as an industry, we're already doing these things, but for instance, in Forney, it'll be 4 years before those guys will ever be 4 years as in 22 before they'll graduate from high school. The problem is the lag time. Once again, it was recognized 3 or 4 years ago this was going to be a problem. It just takes a while. It is going to take a decade to clear up. And if the average age electrician is 48 years old, that's 58 by the time you can replace them. So, Mr. Gonzalez.
David Gonzalez, Compliance Division. I really love what I'm hearing. This is what a summit is supposed to consist of. So you already started the fodder. We definitely need more ideas. We've got everything from education to economics. All these things can be topics. It's such a broad item that we put on here for summit. Make sure to manage the expectations. We are the licensing entity and the regulatory side. So we are getting into ground that I think it's an important discussion for us to have, because we could have an effect on it, but it's going to take more than just us. It's going to take the industry, the associations, the apprenticeship programs. That's what's going to make a difference in this big picture. So I think the discussion is a great thing to have, and I'm glad that we're able to help lead it.
Great. Any other questions or comments concerning this K and us setting up this summit?
One other
Fall
point,
of
Mr. Chairman.
17?
Mark
Yes.
Roach, and just a clarification and a tag on to what you just provided for us, the insight as a school board member. I'm a member of Associated Builders and Contractors, and we were pretty instrumental in pursuing House Bill 5 and its approval. However, we knew that the shortcoming would be that House Bill 5 would only provide an avenue for school districts to follow, to go down. It did not mandate that they did it, and it's incumbent upon industry to put the pressure on the school districts to veer from that 20 years of no vocational education programs, and persuade them to consider, because they've got budgets and everything that they need to live by, and it was a pretty drastic change for them. So the industry needs to understand that school districts are not gonna come to the industry and say, what can we do for, the electrical industry or the bricklayers or the pipe fitter or whatever. It doesn't work like that. Industry needs to put the pressure on the school districts.
Mary Winston, I think I'm gonna, echo what David Gonzalez said, that, you all have given us a lot for the summit in just this short conversation. So what we can do is take this information and any other information, questions, concerns that you have, and this will help us develop the summit. We develop a skeleton template of timeframes, and we'll get the date, we'll have the place, we will market it, advertise it, we'll get it out there. We'll ask you guys if there are places that we don't touch that we can touch to do this. I request that, and I think we all do, that you all, what hasn't been covered here, please submit other information. And the associations and things that you're talking about, we would like them to come to the summit. We, if you can advertise it to them and have them come. We'll come up with a date that is gonna work with your schedules and work with all of our commission meetings and advisory board meetings and other professions that we have to deal with. But sounds like this is much needed, and I don't wanna do all the good stuff here, but we need to kind of cohesively get a program together. So I want us to get this information, other information, questions, concerns, so we can draft and kind of create this summit for a bigger body to be here to discuss.
Chairman Bell, John Sparrow. Mary, where would we submit them, to Tamala or?
Yes, that would be good. We have the advisory.boards email at tdlr.texas.gov. Submit those. If someone is, happens to see Jerry, if you can discuss that, they will get that to us. Because Ray has done this before, David's done this before. We will get this together, and we want to make sure that we're addressing everything. Mr. Sparrow, I have a high schooler too, and they have a lot of academies that do a lot of things, and this is not one of them. So I understand what you're saying.
Great, thank you.
Mr. Chairman,
Yes,
Mark
sir.
Roach, just an add-on to Mary. The more I think about this, the more this discussion is taking place, you guys may need to find a bigger room.
That's okay. Yeah,
This thing
that
gets
is
out the
okay.
industry, I'm thinking this summit could be large.
We can do that. We have Mary Winston again. We have strategic planning. We have gone all over Texas for different things. If we find the need for a bigger room, we will accommodate whatever we need. That would be fantastic. We'll put on whatever we need to put on to get people in. And sometimes we'll have strategic planning or a summit and not have the room as filled as we would like it to be because we've had interest expressed. Then we go back as staff and figure out, where did we fall short of maybe getting the word out? Is this issue not a big enough issue? But it sounds like we're here. So if we get that feedback that we need a bigger space, we'll accommodate happily.
Thank you. So it sounds like it's a consensus of the board to move forward with the summit and schedule that as soon as possible, fall of 17.
Fall September, and we will check out, we'll make sure we get with the schedules of all of our staff and you guys, and we'll also check with you about the different associations and their awareness and what's a good date based on the vacation time or what's a good date for the practitioners to come back in.
Great. Thank you, Mr. Winston.
Chairman Bell?
Yes.
I do want to say something to address this. We've been working with TIVA, which is the Texas Industrial and Vocational Association through Texas. We had 13 electrical programs when we started over 10 years ago. We're down to 11 because we're not getting support from the industry. TIVA is having their meeting up in Irving on the 19th of this month at 2 o'clock. Would like to invite anybody. I've already talked to them. We're doing the presentation, but they would love to have the industry and people that could come in and help them build these programs, because right now, without the industry support backing them, telling the counselors, the school boards, the principals that this is something that's needed, it's a big demand, there's nobody doing it. And the biggest problem these teachers are facing are the counselors after they go get these young men and women installed in these classes coming in as freshmen, and then the counselors convince the parents that they don't want to do this, they want to get ready to go to college. So that's a big issue, and that's what we keep trying to tell the counselors. They may or may not go to college, but don't you think it's good to have a backup plan? This industry for me was a backup plan, and look where I'm at. So you have to look at that, but we would love to have you at the TIVA meeting on the 19th at Las Colinas. It's actually at the Omni Mandolin Bay Hotel at 2 o'clock. If you have interest, give me a call. I'd love to have you there.
Stacy Malcolm, that's July 19th?
Ma'am?
July 19th?
Yes, July 19th.
All right, thank you, Jerry. All right, well, moving on back to item J, is discussion of possible appointment of an enforcement work group to review and make recommendations regarding the penalty matrix. This time, the chair would recognize Mr. John Medlock.
Thank you. Again, John Medlock with the prosecutor's office. So for those of you who don't know what we're talking about when we're talking about the penalty matrix, the penalty matrix is a creation of the enforcement division. It basically lists out all the different types of violations there are within the electrical law and rule. And the prosecutors that are on this team use it as a framework to know what they're charging. So we have different classifications: Class A, Class B, Class C, Class D. Class A is being more like your record type violations, B a little bit more serious, C, and then D obviously the worst. It doesn't create any kind of new laws. It just basically lets the prosecutors know this is basically the framework that we deal with when we're dealing with violations, and it also lets the public know, okay, if I commit this kind of a violation, this is the kind of fine that I'm be looking at. With some of these new changes that are coming up, and some of the House bill, and we just want to kind of get ready to update this penalty matrix, so we're not, because we came into an instance where we hadn't updated it once in 7 years, and that's when we updated it in 2015. We want to go ahead and get in front of that curve, so we're just asking for a work group to help us take a look at the current penalty matrix, see where these new law changes and these new rule changes are going to fit into these different classifications of violations, and then if there's anything that that we don't need in there anymore, that we can take that stuff out as well.
Okay, thank you for your recommendation. Any questions concerning the need to create the work group? I'll serve, typically as the chair, serve on all the work groups, so we can't exceed 4 total. So I'll just take volunteers that want to serve on this work group, a total of 3.
Chairman Bell?
Yep.
I'm local, I'll do it.
Mr. Palmacall?
And for those of you who are not local, it doesn't necessarily have to be conducted here at TLR. We will use technology if we have to conference in, whatever. So if that's a concern, we can make those arrangements as well.
Anyone else want to serve on the work group for the penalty matrix?
If we need somebody, Mr. Chairman, Mark Roach, if we need somebody, I can serve. I'm semi-removed from the contractor in that I'm a supplier, so I get to hear everything that goes on.
Okay. Sure.
Yeah, John Lewis, I'll participate.
Anyone else?
And one more.
Okay.
Marcus Lennegreen.
Okay. All right. Marcus and John and Mark, correct?
Oh, Randy.
Oh,
That's, we got,
I think
Then you have
quorum.
yeah,
five.
we've got Randy and Mark, correct? You in or maybe?
well, if I need to step out, if somebody would rather do it, Marcus, you want to do it? You wanna
That's
sit
fine
on-
with me either way. I didn't
And
realize we
Randy
already had a quorum.
and John, you want to do it?
Yes, sir.
Okay,
Okay.
then I can step out.
So, Randy, John, Marcus, and myself.
Right.
Okay.
And that's short of a quorum.
Short of a quorum. That's right. That's enforcement work quorum. All right, so I will need a motion to approve the work group, including myself, Randy Palmacall, Marcus Ledgren, and John. John, I'm sorry, I keep forgetting your name. Help me.
Lewis.
Lewis. All right.
Mr. Chairman, Mark Roach, so moved.
All right, we have a motion by Mr. Roach. Is there a second?
Randy Paul McCall, second.
Second, Mr. Palmacall. Any discussion? Hearing none, call for vote. All in favor say aye. Aye. All opposed? Motion carries.
Thank you. And we'll get with y'all on dates about when we'll get this together and get you all that information. Appreciate it.
Thank you. Moving on to item L would be recommendations for agenda items for our next board meeting. Obviously, minutes, staff reports, work group reports, proposed rules for House Bill 1698. Any other? All right. Hearing none, that'll give you a start.
Yes.
Ms. Winston. Moving on to item M, discussion date and time and location of next board meeting. According to the timeline we've seen, for sure that'll be in February of 18. However, when we do this summit, that'll have to be posted as a meeting of the advisory board, so that discussion, that date, time, and location will be to be determined based upon the calendar bingo for all those included. So, if there's nothing else to come before our advisory board, it's 11:26 a.m., 11:26 a.m., and we stand adjourned. Thank you.